Hello and welcome to the EDiscovery channel, live from New Orleans. We're reporting post Mardi Gras. Actually, we just woke up here on St. Charles Avenue. We're directly across from Gallier Hall. You can see the dismantling of the reviewing stand going on behind us, and that's the Louisiana Bar Association directly behind us. Several of our colleagues are in there looking out the windows asking, what are those knuckleheads doing?
Nobody ever asked that question in New Orleans. That's the thing.
And of course, yes, a rarely asked question in New Orleans. Gallier Hall, of course, was City Hall at one point many, many years ago. And you know that question was never asked there.
This is our special Mardi Gras edition. That's why we're wearing these beads.
We had hoped to report live from Mardi Gras.
King cake. Rouse's king cake.
There you go.
Hold it. We got.
Unfortunately, Craig was setting a new world's land speed record for attending.
Please don't eat me! Please don't eat me! That's the baby from the king.
Here we are, proving once again our standing as some of the elder statesmen in the EDiscovery world, taunting the audience with king cake babies. As I was saying before I was so rudely interrupted.
I'm sorry.
Put the baby down. Stop playing with your food.
So Tom, you know it.
No, wait a minute. I haven't finished.
Oh, do your shtick.
We couldn't do the live broadcast because you were so busy attending. I'm sorry. How many parades was it?
29 consecutive parades. I am termed a bead whore.
You got the sticker.
By likely, just to know.
He's certified.
Yes, I'm certifiable. Sir.
He's now officially certified.
Moved from Department of Justice to bead whore. And I got the beads to prove it, baby.
So there you go. And so that was what put us behind schedule. So we've now come down after Mardi Gras has finished up, and we're trying to decompress and get ready for our next fabulous.
But in the middle of Mardi Gras, the joy of Mardi Gras was interrupted, was it not, Tom? You had to leave your beloved town of New Orleans and head to the frigid north for what?
You know what? I don't even
remember. I believe it's called Legal Tech New York, though.
It was Legal Tech. I think you say that, you're right. How soon they forget.
Yes, indeed.
Right? I was, in fact, at Legal Tech New York for the first 2 days. And it was not too cold. Colder than here, obviously, but...
a nice change from recent years of terrible weather.
Yes.
Apparently you had easy to get in and easy to get out of New York. So how was the attendance?
As easy as one can get in and out of New York.
How was the attendance? What was the turnout like?
Of course, I'm not keeping official numbers here. I haven't seen the official report on how many there were, but just from my unscientific sample, I thought it was at least as busy as last year, if perhaps not a little bit busier. The exhibit hall, of course, was packed with people. The receptions were well attended. The educational sessions that I popped into, at least, were also very well attended. So I suspect that they were all happy with the crowd itself.
Have you seen some evidence of consolidation in the industry? Is the booth number growing or dropping?
I would say it looked stable from last year. That third floor that they used to have up top has been closed off for 2 years now. I think the Codex people were up there. That Stanford think tank startup proposition that Monica Bay is involved in.
But no, code something that those people who whip themselves in the Da Vinci Code.
Yeah.
Codex.
Yes, but no exhibitors up there. But the hall certainly had no gaps or empty spaces that I saw. That second ballroom with the balcony that they also have exhibitors in was full.
So were there any EDiscovery vendors in evidence?
There was a plethora of EDiscovery vendors.
Oh,
the veritable plethora. Yes, it appeared that everybody was an EDiscovery vendor, from what I could tell, with the exception of, I think, Donna Payne was perhaps the only non-EDiscovery vendor there. Once again, EDiscovery was king. It ranged from both sides of the EDRM graph, so everything from info governance to presentations. People would assert that they were in the EDiscovery food chain. and
in the space.
in the
as it were.
space, yeah. So, yeah, it was well. EDiscovery was well represented.
And did you get any good meals while you were up there? It was New York after all.
No, in fact, it was awful. It was awful. The deli right across the street from the show, on what was that, 53rd
The
Street?
53rd Street Gourmet Deli.
Yes.
Much beloved.
Closed for repairs. The stage.
Why go? Why even have Legal Tech without the 53rd
Oh, it gets
Street
worse.
Deli?
The stage deli, of course, changed hands about a year ago. It's now in a clever play on words that only New Yorkers could pull off. It's now the Coach Deli, right? Formerly the stage deli, now the Coach Deli. But also the Carnegie Deli was closed in the wake of the explosion last year of a restaurant further downtown. I think you might recall a gas meter or a gas line had exploded and killed some people, and the city had been doing.
Yeah, I've had gas issues from the Carnegie Deli the past.
Yeah,
month,
well, they've been doing some investigations or safety checks of gas lines and found. I don't want to make a false statement or an accusation, but the city and the Carnegie Deli are now in a dispute over
who blew up New York.
The accuracy of meter readings on the gas meter in the state, in the Carnegie Deli. So the bottom line is, the three places I would eat routinely were all closed.
Now, the Carnegie Deli is near Carnegie Hall, is it not?
It's at the stage deli is actually 1 block closer, I believe.
So how do you get to Carnegie Hall?
Practice. Everybody knows that. Or I guess in the mode of EDiscovery, process. Then you'll get there eventually.
Well,
so
we do have. So thank you for sharing.
Luckily, it was New York, so alternate food options were readily available.
Alternate food of the side of the food parking was in effect. So, did you see any celebrities?
Celebrities?
Oh yeah, thought leaders.
Oh, thought leaders.
Thought leaders.
You say celebrity, and I thought that last year
rock star judges.
Somebody had Tiki Barber in their booth signing autographs last year. I was hoping that his brother would be there this year, or perhaps Phil Simms or somebody.
I visited the Tiki Barber room at Disneyland once. It was very entertaining.
Well, of course, the usual agenda of judges were there. Judge Peck, of course, who is in New York.
Talking about predictive coding, perhaps?
The subject may have come up. Judge Francis was speaking on a panel. Judge Rodriguez.
We have much to say about Judge Francis today.
Don't recall seeing Judge Shinlin, although I have to assume she was there. I attended one panel on the very first day. So there were a number of judges around, yes. You, of course, were not there.
I was not. First time in 20 years, I did not go.
And Gail O'Connor, my far better half, was not there. So really, the two biggest celebrities in my world were not present. George Socha was there.
Good.
I saw George.
Ralph Losey?
Ralph was there. I did not see Ralph. I did run into a couple of old friends. George Rudoy.
Good.
Is now, I can't recall what firm he's with now. I apologize, George.
It's a big one.
Aiken Gump. I'm sorry. George had recently joined Aiken Gump. Trying to think if I saw anybody else who we know in common, but it was a veritable who's who of people speaking about EDiscovery. So there were no shortage of sessions on the topic, and there were educational sessions well worth attending on all 3 days. Oh, Bill Hamilton was there.
Oh, good.
Bill, partner at Quarles and Brady, and of course, head of the EDiscovery Institute at the University of Florida, Levin School of Law, which is emblazoned in
Bill's one of my favorites.
Yes, Bill was there.
Sorry, I didn't get to see him.
Got to see him. Patrick Burke from Safor Shaw. Spent a nice evening speaking with him, and at an EDRM function. So yeah, there were some of the regular folks you'd expect to see in New York, and some of them were in and out for a day. The one person I did not see, I've not yet emailed him to see if he was there or not, but I always look forward to seeing our old friend Neil Aresti, who likes to come down from Boston just to mingle and see what's going on. I unfortunately didn't get to see him, nor Gene Eames from Pfizer, because like I said, I literally flew in on a Monday night, spent all day Tuesday in meetings and going to some sessions, and then Wednesday morning and left Wednesday around noon. David Horrigan from K-Cura was there. Monica Bay, I did get to say hi to, and our old friend Mickey Tomlinson, who's many of you know, her husband passed away about a year ago. It was her first show back, so I was very happy to see her. She looked great. So, yeah.
And Henry Dicker?
Henry was, of course, there.
Good.
Henry and I managed to smoke several cigars, whose origin shall remain nameless because of our Fifth Amendment constitutional rights to not indicate ourselves. So yes, you know, all in all, for me, it was a good show. Having some great meetings with some folks on behalf of Advanced Discovery, and attending some EDiscovery sessions and meeting with some of the relatively folks. New friend, Vince now I'm going to mispronounce his name, Cataranzo, I believe, from Shook Hardy, who's one of the EDiscovery attorneys, and then also, by coincidence, marches in the Half Fast Walking Club, which is a long-standing institution here at Mardi Gras, started by Pete Fountain, the legendary jazz musician. Vince walks in their early morning soiree through pretty much most of Lower New Orleans, and that's a very great group. The group was originally started by Pete, I guess maybe 40 years ago, where he started at Commander's Palace drinking Bloody Marys, and with his musician friends would start to wander down the parade route just between Zulu and Rex, and he called it originally the Half Blank Marching Club. The city fathers, after several years and increased popularity, asked him to change the name, which he did conveniently, to the Half Fast Walking Club. Now they're about the Quarter Fast Walking Club as the age has gone up. But Pete still shows up. They've got him on a small trolley that they go around. He tries to show up even now for the first third to a half of the parade.
So we've kind of jumped the Mississippi banks here. We're going to move you back into the EDiscovery channel if we can now, Tom. So
Must we?
Well, we must. We must. So
do I have to take my beads off?
Well, I will tell you. Well, no, we're doing this. I'm here because Mardi Gras. The first time I haven't gone to Legal Tech because of Mardi Gras and wanting to really get into it. There's a lot more to Mardi Gras than people who are not from this area really appreciate. They think about Fat Tuesday, one drunken brawl on Bourbon Street. But if that's what you think about when you think about New Orleans, you are missing the real hot spots and joy.
Indeed.
Come earlier, see the 27 parades or more that precede, and I'm just talking about the uptown parades, the ones that come by my newly rented apartment here. And that's why I'm here, Tom, is that I now have a place to split my time between Texas and here. Still a Texas attorney, practicing in Texas, living in Texas, but now spending much more time here with my good friend Tom and Ernie the attorney. And
one
others.
Foot dipped into the Mississippi.
Yeah, once you've tasted the Crescent City, once you've been to the city that Care forgot, it's hard to return anywhere else.
A slogan I have never understood, but so be it.
Well, because the city that Bush forgot didn't seem to catch on with the locals for some reason, although it was as accurate as could be.
You're doing a great job there, Brownie.
Let's talk a little bit about. Browning would never have said that. There's no question that our dear friend Browning would not have made a Bush reference unless it was reverential.
Yes.
All right, so let's talk about some new cases. We actually have a purpose.
I mean, there's been like legal business transpiring for the past several weeks
during Legal Tech and Mardi Gras. Who knows what could have happened? Most of these actually occurred last month.
I should note that we talked about the buildings behind us, but we are looking directly at the federal courthouse and the Court of Appeals to its right, and the bankruptcy court over here directly to our right.
The Fifth Circuit here.
Yes. So we are certainly in the hotbed of legal activity in New Orleans. So tell me, new cases?
Well, let's put a little spread on this bread. Fifth Circuit right to our right. What does that have to do with it? Well, as you may recall, Tom, we had a split in the various circuits with respect to spoliation sanctions for loss of electronic information, right? We had a couple of key cases, battling cases, if you will, between the judge in the Fifth Circuit, Judge Lee Rosenthal, and a judge in the Second Circuit, Judge Shira Shinlin. and they pointed out, oh, hold on, we're going to have a special effect here, just to show we're really in New Orleans, folks. I bring you the St. Charles Avenue streetcar, the streetcar once named Desire. And
no, that was not the streetcar named Desire.
Well, actually, no, it wasn't named Desire. It had the word Desire on it because it was going to a tenement named Desire, and that's why it said Desire on the streetcar.
And that was actually the streetcar that went up Royal Street through the French Quarter. In fact, if you ever come to New Orleans, we will be happy to point out to you the building where Tennessee Williams wrote that play. He originally called the play The Card Game because the characters were playing cards. And he used to sit in the window of his room looking down on Royal Street, and the streetcar that said Desire on it stopped right on the corner in front of what was then an A&P, is now a Rouse's. And he immediately thought to himself, that would be an ingenious title, and everybody would think I was a master of double meanings by calling the play The Streetcar Named Desire, when in fact it was just pure happenstance like this as a streetcar rolled by. But I digress. I'm sorry.
No, it's quite all right. Anyway, the point is, Fifth Circuit right here, split between the circuits, resolved most recently not by a Supreme Court opinion, but by amendments to the rules. Now, we've touched on these amendments, but these amendments are now being put into play. And so we have 3 cases, all within literally 2 months of the time that the amended rules went into effect on the 1st of December of 2015. We've got a case out of the Southern District of California, we got a case out of the Southern District of New York, and we have a case out of the Northern District of California to chat with our friends today. First case is Judge Moskowitz's decision in Nuvasiv Incorporated versus Madsen Medical Incorporated. And this is kind of an interesting case to me. Basically, last July, Judge Moskowitz sanctioned one of the parties for failing to enforce a litigation hold such that certain messages, texting was deleted that was crucial to the case by various executives. At the time, the court found that the appropriate remedy should be a permissive adverse inference instruction that would allow the jury to conclude that the absence of the text messages is such that those text messages must have been bad for the parties that failed to preserve them.
Okay.
Now that is, of course, the so-called 2E kind of remedy. Anytime you start telling the jury that it may or must have an adverse inference, you're falling into that realm, a very specialized realm called the 2E realm within Rule 37E as amended. And what happens there is that's reserved for certain very serious sanctions, kind of case-killing sanctions or death penalty sanctions like dismissal of the case, striking of pleadings, etc. Now those sanctions, as you know, under 37E, can only be applied by the court for loss of ESI if there's a finding that there was an intentional effort to deprive the litigant of that information. So the court, although it had already, under the old rules, found a sufficient sanction in order to justify an adverse inference instruction, albeit a permissive one, the court is asked to reconsider the case. That's interesting. The case was to have been tried last year, but due to conflicts in the court schedule, the case got continued a little bit past the effectiveness of the new rules. And although the court did not have to do this, because the court was free to apply the old rules, the court nevertheless elected to reconsider its own sanctions.
And by the court, you mean the trial court?
I mean Judge Moskowitz, yes, the trial court. Now, mind you, the case hadn't been tried yet, and the sanction hadn't been put into place in terms of the instruction of the jury. This was done on the eve of trial.
Do you know, did he do this on his own?
No, it was a motion to reconsider that was filed in December.
Okay.
And right after the rules went into effect. As soon as the rules went into effect, the company, I think it was Madsen Medical, moved for Nuvasiv moved for reconsideration.
And asked him to apply the new rule standard?
And asked them to apply the new rule standard when reconsidering. The court did. And so, yeah, this is because it's noteworthy because the judge didn't have to do that. The judge came into it with an air of, oh, my hands are tied, the new rules have changed. But if you look at the enabling rule or the text of the amendments themselves, they make it clear that it's left to the sound discretion of the court whether or not to apply them and the court doesn't have to apply the new rules if they will work an injustice or a hardship. And so the court went ahead and reversed itself.
Interesting.
And sadly, I think it's really bad luck for Madsen Medical, as the court describes. The court really calls it a matter of luck, which I think is interesting because it was up to the court, and the court puts it down to bad luck. Bad luck that I continued the case till the 2nd of February. Bad luck, that means the new rules are in place. So, as it turned out, bad luck for Madsen Medical, and this happened on the eve of trial. So whatever strategy they'd had to build their case around the adverse inference instruction went out the window on the eve of trial, and bad luck.
And did the trial continue as scheduled? Did they ask for a, do you know?
I don't know. I did not do my follow-up to see if it went into trial.
Given your statement there about, on the eve of trial, it seemed they
might have what?
Well, I just thought it might have affected their strategy on how they had intended to proceed. But.
So my question is this: I mean, didn't they see these rules coming? These were not like the surprise jack-in-the-box rules. These things were pretty much in the can by July of 2015. We've been waiting on them to work their way slowly through the approvals process, but no one expected them to change fundamentally.
See, I think when you say we or no one,
the EDiscovery nerd community,
you're talking about perhaps 1% of the attorneys in the country. I mean, I think we've been astonished since the original set of rules went into effect at how many people were unaware of them.
There were two. A lot of people listen. There were two sets of rules.
Yeah,
2006
exactly.
And 2015.
Yeah. I mean, I just today received a message from a firm in California asking for a CLE, if we could provide one at Advanced, on the new rule changes. And it became clear in the course of the email exchange that they had just become aware themselves of the new rule changes.
The 2006 ones?
No, that's what I said. You're mentioning 02 sets. I said, we're talking about the changes from last December, right? And there was a pause where I think somebody in the room was talking to somebody else, and yes, the 2015 change. So, no, does it surprise me that people would not have been aware of it or hadn't planned accordingly? Not in the least. Unfortunately, not in the least.
We have another case where Judge Francis, we were talking about Judge Francis.
Yes.
Jay Francis is, in my opinion, one of the unsung heroes. He doesn't get all the attention that some of the other EDiscovery rock stars do.
Yeah, I was just going to say, he's not the rock star. He's more like the bass player in the Rolling Stones.
To me, he's the Yo-Yo Ma of EDiscovery. He's the maestro of the law of EDiscovery. He's quieter than some, but whenever he writes about EDiscovery, I'm often shaking my head. And that is a sensible decision. He's made several very controversial decisions involving cybersecurity and EDiscovery.
And so what does he bring to the table now?
The most recent one is a case called Cat 5, I believe, or Cat 3, one of those cats, versus Black Lineage Incorporated. Black Lineage Incorporated. Southern District of New York. Judge Francis weighed in, and what he said is dicta, but it's important dicta. And so this is a case where an effort was made to falsify evidence. This isn't one of those, oh, gee, we forgot to put the tapes. No, this was a very focused effort to change some emails. It involves a trademark dispute, and a key issue was whether or not they were aware of the use of this competing trademark when they came up to use a trademark called Slam X Python.
And when you say change, you mean alter the words in an email?
I mean alter the addresses so that the use of the mark was in place. There we go. Hello. Wave hi to the camera, everyone. They're not waving, are they? Okay. There you go. Okay. So we were
interesting.
Yeah. So the thing is, whoever went and did this change to try to win the case changed the domain names of the individuals who were receiving the email, and the theory was because you saw we were using the mark in the domain name, you knew that this was a mark in commerce, and therefore we were, first in time.
Pretty substantial change.
I mean, it was a real Hail Mary pass in terms of stupidity, but it breaks Rule 1 of fabricating evidence. Not that I want to make this an instruction how to fabricate evidence, but
no.
Rule 1. be sure the other side doesn't have an unaltered copy of what you just created. That's always a good rule, don't you think? Of course they did.
And they compared them. And
well, they actually got it through computer forensics.
Okay.
So what happened is that, and it's kind of interesting, because they get this thing and it's like, those don't look right to me. What would you say? You get it on PDF. What do you say, right? What do you want?
Oh, what do I want?
Yeah.
I'm sorry.
What do you want? You've gotten it in PDF. You want to know what?
Give me an A.
What?
Give me an A. Give me a T.
Give me a P. Give me an S. Give me a T. I want native files.
Native
files, exactly. And so they pushed back asking for native files. And when they did that, the lawyer withdrew. It's kind of like, oh, okay.
Wow.
Maybe there's something not quite, noisy withdrawal kind of thing. Anyway, lawyer leaves, and new lawyer comes in, and so they end up ultimately giving a PST. They turn this over to a forensic examiner. They even get their the falsifying side, the ones who would benefit from the falsification, even had their IT guy testify that, and I love this. He said nobody would have doctored, falsified, or materially altered any of these documents or files without my knowledge or approval, because he claimed, and I quote, that he is the gatekeeper of all systems. Now, I don't know. I mean, when I hear about the gatekeeper, I'm thinking, gatekeeper? Are you the gatekeeper, or are you the keymaster?
Tell me you're not gonna make a reference to
Zool, the gatekeeper of Gozer the Destructor in the Ghostbusters? No, I wouldn't dream of making such an obscure reference.
Good. You had me scared there for a second.
Who are you going to call?
Who are you going to call? All right. Yeah.
So anyway, the forensic examiner
Holy
said,
shnikes.
yeah, this could not have happened except for human intervention, and I understand where he's coming from. And in the process, he finds the originals, the unaltered originals, that are sitting behind. I'm assuming, it's not clear from the opinion, but I'm assuming he found that in the uncompressed space of the PST and brought them right back. I mean, this is a real hack job. As Paul Grimm would say, the gang that couldn't spoliate straight.
So it was a significant material alteration, but also an inept one.
Yes. Again, violated Rule 1. Don't change the thing.
So
when you
what did Judge Francis have to say about this?
Well, I'll get there, because Judge Francis had some choice words. Because in defending this behavior, they really didn't come in and say they weren't altered. They would pretty much been caught hand in cookie jar. So then the question becomes, did they know? Was it done intentionally? And so they bring in some guy named Paul the Network Doctor. Folks, I do not make these things up. Paul the Network Doctor comes in. Guy has no forensics training whatsoever. He's a manager. He's a manager for a cybersecurity company, I believe. And so Paul the Network Doctor comes in and testifies on this harebrained idea that maybe that when they transferred from Lotus Notes to another system, maybe the software substituted the domain name.
Yeah.
And the court quite wisely says, they don't explain how this only happened to just this email.
Yes.
And why it didn't happen to any others that weren't key falsified evidence of the case.
Remarkably focused change by an arbitrary piece of software.
Exactly.
Yeah.
And so anyway, Judge Francis, very, very smart guy, sees right through this.
Rejected that argument?
Yeah, but interestingly, they moved to strike Paul the Network Doctor's testimony. Okay. And Judge Francis, very wisely, I think, didn't do that, allowed it to, even though it was untimely, they only, we don't want to take this right now. Paul the Network Doctor, so Judge Francis decides to let Paul the Network Doctor's testimony stand, as flawed and belated as it was, and I think that was smart, because that allows a cleaner record. It's one less thing on which they could take this decision off. Wouldn't have a leg to stand on anyway, it seems. But I guess one should never be surprised when Judge Francis does something smart. I expect nothing less of him. So anyway, they next argue, and this is really canny of the spoliators. They say, you can't sanction us under Rule 37E, Judge, because the forensic examiner got back the unaltered version of the altered evidence. Therefore, there's no prejudice. We've restored that information through the discovery process. You shouldn't sanction us. And here again, the judge.
Wait a minute, let me see if I get this straight. You caught us cheating, but we came clean. Sort of like
They didn't come clean. They got caught.
Yeah, well, that's after we got caught, we came clean and gave you the real stuff. No, we didn't really give it to you. You had to have a forensic guy go and find it.
Right.
But despite all that, we're talking like the FRCB version of no foul, no harm, no foul.
Exactly, and the rule is written with the goal in mind that if you can get the evidence restored, that you don't move to the serious sanctions part. Well, Judge Francis very wisely was going to have none of that. And he said, look, the fact that you're still trying to use this bogus evidence, they didn't give up, they're still trying to use it in their case, is such that there's enough uncertainty about the integrity of the evidence that the prejudice is real, the prejudice is enduring, and so he threw that out. But where he goes a little off the reservation in a very interesting way is, even though it's dicta, Judge Francis goes to some lengths to point out that even if I couldn't apply Rule 37E, even if you were right about that I can't get to serious sanctions because you restored it, I would still have my inherent powers to protect the integrity of the judicial process. Now, what makes that controversial, Tom, is that the language of the rule, the language of the comments makes very clear an effort to limit those very inherent powers.
Right.
They caution against using your inherent powers in a way that effectively defeats the prescription of those Rule 2E serious sanctions. Well, the judge, he gets
having no part of it.
He gets feisty on that, and he says, look, my inherent powers are still my inherent powers. If I find that they acted in bad faith, as I do here, because in this instance, that falsification of evidence is clearly an example of bad faith. So I would have these kinds of serious sanctions available to me, even under my inherent authority,
wow,
which makes mincemeat of a lot of what people thought of Rule 37E. And I think he has the better argument, which is, if you find bad faith, and you find serious efforts to disrupt the process by the destruction of evidence, that is not an actor we want to protect, right? That is, we don't want to give them the technicality of 37E. He almost feels
compelled to address that.
The power of Zool compelled him. the keymaster, the gatekeeper compelled him. The power of Gozer, the destructor, was at work there. So thank you for that very interesting dicta. And it'll be interesting if we ever see a case where the court says, I can't use 37E, but I'm going to throw the book at them anyway under my discretionary power. So that was that case.
And you've got one more for us.
I do. The only problem is, one thing I will add, and I really do admire Judge Francis, but I haven't figured out why he was so lenient. Because when all was said and done, the only sanction he put against this intentional spoliation, this creation of false evidence, which is about as, that's kind of right. That's right up there with perjury.
Yeah.
That puts everything in jeopardy. Is that he shifted some of the costs of proving it up. He shifted the costs of proving up the falsification, and he required that they couldn't rely upon the falsified evidence.
Okay.
I think there needed to be a little more sting in that slap on the wrist, frankly. But as I say, Judge Francis is a very, very smart fellow, and I think there's probably more method to his madness than I could see on the bare record. And so because I know him, I won't consider this Christmas for fraudsters. But if it had been in anybody else's hands, I would have said, that's just not enough. And the third and final case, shall we talk about one more? Do we have time? We will anyway.
Yes.
All right. Well, third one is from another...
What Craig doesn't know is I'm going to cut this thing. The editing process.
My best parts are on the cutting room floor. But this is the educational part, right? This is the ostensible purpose of these videos. It's not just for, please don't eat me, king cake baby references.
Like I said, the editor will speak later.
Yes. I always lose my best bits to the cutting room floor.
So,
I could have been a contender.
I could have been a contender.
Okay.
What do you got for us?
Last case involves another budding rock star of the EDiscovery bench, and that's Judge Paul Greywall of the Northern District. Now, there's not much to this case. I don't really know why it got I know why it got the attention. It used the magic P word. And by the way, P word is not just what we're going to call Lee Circle now that it's ringed with urinals. there's a little
Yeah,
controversy
don't even
down
go
here.
there. Don't even go there.
Changing the name of a place's name for Confederate heroes is a little bit of a problem here in New Orleans. Anyway, they're coming up with all kinds of names for Lee Circle.
Let's set the record straight.
Yes.
Lee Circle is a common euphemism used to describe the circle, the rotunda, where a statue of General Robert E. Lee stands. The actual name was never formally changed by the city council for Lee Circle.
And what was it before?
I
What is
have
it
no
now?
idea, and probably nobody on the city
Well,
council does
based
either.
on the ring of porta potties, I'm proposing we call it P Circle. It'll mean less change for the signage, and it's certainly no one's going to think it's a tribute to Robert E. Lee that his circle stands amidst a bunch of porta
It was
potties.
an attempt, somewhat half-hearted attempt to name it in honor of Alan Toussaint, the great local musician who passed away last fall. But I think that really, at this point, the mayor would just like to get the statues down and let the issue die before they think about any next steps. So.
Sure, throw in the sympathetic dead guy reference. That just killed my jokes right away.
Yeah.
They're dead in their track.
Yeah.
All right, back to Judge Graywall.
Yeah, Judge Graywall.
And Gilead Sciences versus Merck and Company came out January 13th last month. Judge Graywall, Northern District of California. And Judge Graywall tipped his hat to the concept of discovery proportionality.
Mm-hmm.
Now, we all know that after years of effort, the amendment to Rule 26 was such that the proportionality requirements, the proportionality aspects were moved up in the rule. Some 26B2C3 up to whatever, 26.
But I think that that's important to mention, is that these amendments did not add proportionality, right? Proportionality had always been in the rules. It just sort of took some references in different places and combined them and moved them up.
I certainly agree with you in principle. Those who are advocates of this would argue that no, proportionality is now an integral part of the scope, of the defined scope of discovery, and so before discovery can be pursued, it must be proportionate.
It makes it mandatory, if you will.
In a sense. So those who will be arguing it, and they will
Do you
have
agree
the
with that
benefit.
position?
I think that it's wishful thinking that it's going to really make a difference, but we will see. Certainly, Judge Graywall has turned to the concept of proportionality, and in the Gilead Sciences case, where they were fighting to get more and more information on some containers of some specialized compounds they see in a photograph. Mind you, this wasn't even an EDiscovery case.
Right.
But they used the P word, the proportionality word, and so everyone gets so excited when they hear the word proportionality used by a judge that it gets written up as an EDiscovery case.
Okay.
So here's what we have is basically Judge Graywall found that he had the discretion to cite proportionality considerations, to put the kibosh on unduly burdensome or oppressive discovery, and surprise, he still has that power. We've always had that power, still have that power to lessen an undue burden on people. And so there you have a brief mention of Judge Graywall's Gilead opinion. I don't think it's going to change your life.
But you think it's a harbinger of more citations to proportionality? Are we going to hear more of this?
I think having won the race post thing to say the word proportionality, I don't really think it's a harbinger of much at all. Proportionality will be yet another tool in the judicial toolbox when they want to provide a defensible analysis for why they're going to say no. They'll use the proportionality framework and analysis. When someone wants to object, they'll use the features of proportionality. Proportionality is either sand for the gears or gumming up the works, depending upon your point of view.
Don't you think that parties, however, will use this in motion practice?
Oh, sure. Yeah. Absolutely. We've got a whole new level of motion practice. Probably have to bring in experts on certain aspects of it. It will, instead of making things easier, it's going to make
You can be the proportional doctor.
That's it, network doctor. Craig, the proportionality doctor.
That's right.
The doctor is in.
The doctor is in. That's right.
You know, I've always felt that when the courts were actually very skilled, that when they saw discovery that offended them because of undue burden or cost, they could step in. We had a very robust approach to request protective orders. We had all the language, all the tools the judge needed. What these amendments speak to is the need for judges to be more aggressive in the management of cases. And if you read the comments, and I heartily commend them to you, you'll see that the rules are as much about bringing judges more into the process as they are equipping the parties with more tools to promote cooperation and communication.
Well, on that note, I think we're going to have to go eat some.
Don't eat me!
Oh, I think some king cake needs to be devoured here. We will certainly look forward to. Well, now Craig's going to show off. Now he looks like a gatekeeper, right?
Luke, I am your father.
I just got a new helmet and a new scooter, so I'm playing.
Well, I really don't know what to say to that, except thank you for joining us in the EDiscovery channel. And
throw me something, mister. Throw me something. Oh, I lost my mic.
We'll see you all next time.
Unplugged.